Hello friends, we are going to discuss about section 17 of the Arbitration and Conciliation Act 1996. What is this section 17? Section 17 is interim measures ordered by the Arbitral Tribunal. This is basically the interim measure not by the court but by the Arbitral Tribunal, and after constituting the arbitral tribunal, after appointing the arbitrator, the parties may request the arbitral tribunal or the arbitrator, the presiding officer of the arbitral tribunal, to order to safeguard the property, assets, amount that is involved in the dispute as a subject matter of the dispute, or in connection with the subject matter of the dispute in relation to the dispute in total. Any amount, property or assets in connection, directly or indirectly involved with this dispute, to safeguard that asset, property or any amount, the party to this dispute, the party to the arbitration agreement, can apply before the arbitrator to issue interim order. This is an interim measure to safeguard any of these subjects of the dispute. Now, pending the award, pending the final decision, that is, during the continuance, during the proceedings, before the award is passed, the arbitrator, arbitral tribunal, is empowered to hear the application under section 17 filed by the parties. Now, this is in contrast with the power of the court to order interim measures under section 9 of the Arbitration Act. Under section 9, we discussed that the court is empowered to order interim measures for any of these protections, like any detention, preservation, sale of any of the goods, or appointing receiver, or appointing the guardian for the minor, or guardian for the purpose of unsound mind person, for the purpose of participating in the arbitral proceedings. However, this is slightly different from the power under section 9. We are discussing about section 17 of the Arbitration and Conciliation Act 1996. Section 17 is the power of the arbitrator, arbitral tribunal, to order interim measures. Now, this power is also, this interim measure is also for preservation, for protection, and for appointment of the receivers, any of such safeguarding activity. This power can be exercised by the arbitral tribunal. And this section 17 is akin to the standards that are prescribed for the interim measures or for the orders by the court as per CPC. CPC, Civil Procedure Code, prescribes under Order 38 Rule 5 and Order 39 Rule 1-2 the principles what are prescribed in Order 38 Rule 5 and Order 39 Rule 1-2 guide similarly for the order under section 17 of the Arbitration Act also. It is not mandatory to follow those guidelines. However, the interim measure ordered by the arbitral tribunal under section 17 is completely equitable in nature. It is based on equity principles, and that way it is very necessary to follow the equity principles guided under Order 38 Rule 5 and the Order 39 Rule 1-2 of the Civil Procedure Code. Now, what are the standards while granting this interim order under section 17 for the arbitral tribunal? Whether it is to follow the standards prescribed in the uh, court, like prima facie case, balance of convenience, and irreparable loss, whether all these three or any of these to be established by the party making application under section 17. Of course, yes, though not mandatory, but yes, it is uh, governing principle of equity that an arbitrator shall have to ensure these standards, that a party shall establish the prima facie case and the irreparable injury and the balance of convenience for ordering the interim measures under this section 17 of the Arbitration and Conciliation Act. Now this section 17 order, whether it is appealable, yes, it is appealable under section 37, same as it is provided for the section 9 of the Arbitration Act 1996. Any order granting or refusing to grant the interim measure under section 17 is appealable under section 37 of the Arbitration and Conciliation Act 1996. Now, what is the enforceability of the order of section 17 granted by the arbitral tribunal? With regard to the enforceability of the order passed under section 17, it is equal to the order of the court. It is enforceable, and any disobedience, any disrespect, any non-compliance of the order of section 17 ordered by the arbitral tribunal will be dealt with as a contempt of the civil court, and the party can file for an action under the Contempt of Courts Act 1971, as if it is a non-compliance, disobedience and disrespect to the order of the court. And the order under section 17 cannot be directed against the third parties, as it happens in the case of the power of the court under section 9. This is a quite contrasting point, comparing the powers of the court and the powers of the arbitral tribunal under section 9 and section 17 of the Arbitration Act. We know that section 9 empowers the court to order interim measures, and section 17 empowers the arbitral tribunal to order interim measures. However, the court's power has more ambit and unlimited compared to the arbitral tribunal's power, because the arbitral tribunal cannot order the interim measure against the third parties. However, the court can order against the third party under section 9. And this is the brief of section 17 interim orders ordered by the arbitral tribunal during the proceedings, before passing the award, and not after passing the award. I have given the landmark cases, important judgments in the description of this video. If you have any doubt, if you have any questions for discussion, you are welcome to raise questions, and I'll be happy to answer those questions. Thank you.